Pardon me, my lord. This matter relates to code number 23, my lord. Code number 23, madam, my lord. I have paid for review of order dated 11/2/2025, my lord.
What is the urgency?
My lord, the review petition, my lord, reviewing the order. The review petition against the matter number 25 of 2022.
What is the urgency?
This was the local proceeding is going on for recovery of money, my lord.
Tomorrow, the one day they are not coming. Yes.
Pilot like a missing I have. Criminal often have filed an application at the interim level. So appellant is in custody for more than 12 years.
Give it, please.
Another application is a single case matter of the lawsuit. Single.
Mention when I am sitting single today. Yeah.
This person custodian more than 12 years. At this person custodian more than 12 years.
Give it, please.
Pardon to mention only item 7 may kindly be taken up after.
Wait. Yes, where are they?
Supplemental list, item number 1.
Yes, Mr. Asutosh Kulkarni.
Yes, Good
morning, my lord.
And Lankeshwar Ahmad. Mr.
Yes, sir.
Ahmad, are you able to hear
Yes,
us?
sir. Yes, sir. Yes, sir.
And what about the compliance of the order of this court?
Sir, ଆମେ କମ୍ପ୍ଲେନ୍ସ ସବମିଟ୍ କରିଛୁ ସାର୍ ଆମେ ତାରିଖ ଯୋଉ 20 ଜାନୁଆରୀ 25 ର ଯୋଉ ଅର୍ଡର ପାଇଲା ପରେ ସାର୍ ଆମେ 29/1/2025 ରେ
Where is your compliance affidavit?
That is at flag B.
ସବମିଟ୍ କରିଛୁ ସାର୍।
Come to paragraph number 6. Tell us the date, don't say go here and there. We are not here, sit here to, we want the order to be complied with, that's all.
Trying to justify unnecessary.
Yes.
Why are you writing so much? Comply, comply, or not
No,
comply?
unless, with the acknowledgement must make a solution.
Otherwise, you will either, two options are likely to. Send back to the jail or stop your salary.
You will also kindly see, in the meantime, by order dated 5/5/2025, passed in WPC number 10570/2025 under Annex D by 1, the process of eviction has been stayed by this court. Just 2-3 days back. You will also will get it page 28, running page 28. The
28.
same shop owners who had approved the Honorable Apex Court, they have come up before Supreme Court by filing a writ petition. 28 notice was well filed for a 14 notice has been issued. Then IA 6162/2025. Relevant portion is page 29.
This is totally different, just some penalty, etc.
No, no,
Let me appraise your lordship.
Yes.
I'm appraising.
What has happened there, that lordships have taken into consideration that there has been a violation of the order of the division bench.
Yes.
Because if your lordship will find on him they have issued this, which is annexure 6 considered there, they have given it annexure A by 1. If your lordship will find that they have failed to comply this part of the order, that your lordship can get here, that page 35 of that order which is non-compliance. Well,
Come to that.
last paragraph, page 35
Just a minute.
of the contempt petition.
Contempt petition.
Minor.
That is the order passed in WPC number 112.
Yes.
That is plus starts from page 34.
Let
WPC
no move submit karo. Let's kindly see.
WPC 11223 of 2015, page 35, yes.
Yes. Well, the first part of the order is that the shopkeepers will vacate within that time.
Very good,
Don't
very good.
vacate, they will be evicted.
Very.
And the first part of the order, my lord, let's kindly see, I'm reading. Disposed of. First, I'm reading for convenience, I'm reading from the beginning. Let's see, from the first sentence. We are of the view that till the Routledge Development Authority. Well, page 35 of first line before contempt.
We are of the view.
Man. We are of the view that till the Routledge Development Authority complete the part of the project as taken, that they will complete the basement and ground floor within a period of 6 months, excluding this rainy season, and give allotment to the shopkeepers who have occupied the same. In view of the undertaking given by the Routledge Development Authority, we direct the opposite part number 4271 vacate the land occupied by them pursuant to the earlier direction issued for eviction of these petitioners within a period of 1 month from today, that is on or before 15/6/19, and all these opposite parties will furnish an undertaking before the Routledge Development Authority that they will pay the license fee within a period of 4 weeks from the date of vacation of the land to the authority, as well as they will also give an undertaking that they will not create any hindrance for construction of the basement and ground floor in the meantime. In such event, the Routledge Development Authority will allot the subroom after the construction is completed within a period of 6 months We also direct that construction shall be completed by March 2020. The allotment shall be made on completion of the construction in favor of object part number 40 to 71 who have occupied the land. Well, this is a precondition. Then, Lordship, kindly, this is very important. Why they had come to in the single years. It is also submitted that there are availability of vacant land where the opposite parties number 40 to 71 can be accommodated, and for that, in case the opposite party number 40 to 71 will file petition before the Rehabilitation Development Authority for allotment of such vacant land, and the Rehabilitation Development Authority will consider their application and accommodate them for a temporary period till the construction is completed, and fresh allotment will be made to them. In such event, the persons who have occupied the land by virtue of such temporary allotment will also give an undertaking before the Rehabilitation Development Authority. They will vacate the temporary allotment land immediately after the sub-rooms are allotted in their favor in the newly constructed project, and the persons who have not vacated the land will be evicted with the assistance of the district administration within a period of 1 month from for non-compliance of the court's order.
Yes.
So now, Lordship, kindly come to the order of the honorable single case. That your Lordship from the compliance affidavit, that your Lordship will get page 26.
20,
26.
23.
6. 26.
Yes.
Para 8. It is the further submission of the Learned Council for the petitioners that in terms of the earlier order passed by this court dated 15/5/19, well, this order what I read out, the present petitioner made a representation on 22/5/19 for allotment of alternative accommodation so that they can comply with the order of this court in letter and spirit and vacate sub-rooms land as allotted. Learned Council for the petitioner, Mr. Chaudhary, submits that though admittedly the representation made in terms of the direction of this court is pending consideration, the impugned order at Annexure 6 has been issued, passed, alleging that the petitioner have violated the order of this court and unilaterally allotment of the sub-rooms has been cancelled in utter disregard of the order of the court which had attained finality. It is the submission of the Learned Council for the petitioner that the condition precedent for passing the impugned order, well, that is the condition precedent as per the division bench order, at Annexure 6 having not been patently adhered to and facing imminent threat of eviction, this court has been approached and the petition merits consideration. So that is why we pass. And this Annexure 6, Lordship kindly see Annexure A by 1. So immediately Supreme Court dismissed. On haste, they have issued this 29/1/25, that is Annexure page 11. That is the order. That is the order. And Millard, to justify their action, this is the Annexure 6 in that regard. So Millard, immediately before filing this,
You please answer in the earlier round of litigation, 40 to 71, the parties.
Yes.
40 to 71. They are the petitioner here also in the
WPC number 10.
the same petitioners.
That has been stated in the order. You will find that comparison statement is there. That you will find.
That is at page 22. Last.
Page 20.
Page 22.
22. Start from page 22, 23, then 24.
You are there. You are the same.
There. And your Lordship will find B by 1 series, C by 1 series, and D by 1 series. All these are the documents that they are asking for the land, that alternative land for temporary relocation. So they have issued subsequently. And this has not been brought to the
But for this order, how the earlier order of division bench can be complied?
division bench.
Can't have both.
Both.
Can't have both.
Division bench order is there. So division bench order is there. That means they have to do, that is their lookout within what time they have to comply. Because they have not
No,
complied.
division bench only said that the alternate plot will be considered.
Yes.
There is no direction to that effect.
That is
You are-
all, that is all.
Here you are saying that our application is pending, so therefore you can't evict me.
No, yes, there's, no, division bench said that they will be relocated and will be evicted.
No, for the purpose of that, you have to give a representation. They will consider it.
They have given,
That's what the division bench said.
they have to give.
Division bench has not given a mandate.
Well, I am,
Have to give.
I am not for the shopkeepers. They have entered into agreement with me. I have deposited money, everything, for taking up the construction on behalf of RDA.
But these the shopkeepers are creating problem.
Shopkeepers are creating problem.
Then
And
They were money.
if they comply,
But
there is a problem. If they don't
they-
comply, there is a problem.
They are parties to the division bench order, which has been confirmed.
It's all right,
But things are that, well, they have taken the steps here, they have stated. But it is yet to be said before the signatures.
So therefore, unless this petition is disposed of, it's difficult for them also. That's what
Well,
you are also conceding to that.
But that aspect, they have to take up the matter.
No. Thing is that this order has come, so
one more aspect with.
But they have to, the division bench order is there, division bench judgment is there.
no, this has been considered by the variance single judge. It's not that it was not brought to the notice.
No, that got to the notice.
Yes.
But what the Honorable Single Judge said, that you have violated that order of the division bench, which has attained the finality, but instead of relocating them, you have. So they have to relocate, the relocation part is there before your lordship.
That's no. In the contempt jurisdiction, we are not going
Yes,
to.
plus, it's a strict
At least they can, they can be given some time, but how this division bench order will be.
We can't add anything to it.
with due
Whether content is made or not, that we have to see.
That is right, that is right.
whether
But this is a situation how the division bench order will be complied, that is your lordships have to consider.
no, it is also the order of the Honorable Supreme Court. Because it is confirmed.
That is confirmed.
And confirmed in particular. Would you apply?
Have you intervened in this matter, single judge?
No, we have not.
You intervene and tell that.
That we can intervene, but that is their responsibility, na? That
What my
they have said this.
Plus, I am in a contempt.
Violation of the order of the division bench they have issued, they have to clarify.
How these persons are violated? That's the question. How these two persons are violated? Plus, your lordship can come to page 35. Would you apologize?
No, you have not relocated them, but you issued them.
My learned friend just.
Your lordship got me. They have not relocated, but issued the notice. That is why the Honorable Single Judge had taken.
Lordship can come to page 35.
That aspect of the order is not complete.
Because six,
What is there in 33?
because six timelines have been prescribed. I have also explained in my complaints affidavit. The lordship can come to page 35. I am just reading it very minute because I have also gone through the entire order. We are of the view that till the Rourkela Development Authority completes the part of the project as undertaken, that they will complete the basement and ground floor within a period of 6 months. This is first timeline. Within a period of 6 months, excluding the rainy season, and give allotment to the shopkeepers who have occupied the same. Then, in view of the undertaking given by the Rourkela Development Authority, we direct the OP number 40 to 71. These are shopkeepers to vacate the land occupied by them pursuant to the earlier direction issued for eviction of those persons within a period of 1 month from today, that is on or before 15/6/2019. This is the second timeline. And all these opposite parties will furnish an undertaking before the Rourkela Development
What
Authority.
are you trying to find out the mistake?
My humble submission is, one fellow has been confirmed in the Supreme Court.
Yes.
Because these timelines,
Wrong, right, whatever. We are not going to.
the important.
We don't want.
Don't know. You are that.
Maybe wrong order. Maybe wrong order. You should have gone and challenged.
No, that I am not saying. Probably I could not communicate your lordship. That is because by March 2020, the construction should have been completed. Because these persons are not there in position. These persons are not there.
Whosoever now in charge, they are to not that the persons who have retired.
Unless I don't dispute, but by that, whether those timelines will be auto extended.
Because you challenge the order in the honorable.
Or it should be refixed.
So there are static order.
Only within 1 month they have filed the content application.
We in this jurisdiction, all these things are immaterial.
It's a contempt loss.
Contempt, we will extend this order. We can modify this order.
No, you are also.
Fix a timeline. Can you fix
No,
time?
no,
Then
no.
why are you telling all this to go?
It has to be done.
It has to be done or not done. That's your outlook.
Only thereafter, unless timeline is fixed, Then,
Who will fix the timeline? We will not fix the
no,
timeline.
your lordship,
Why are you telling us?
that is,
You
I
go
am explaining.
to the court where they
Yes,
can.
I am explaining how the first content was dropped, your lordship will get it at page 6 of the content.
You are justifying a stand that at that point of time when the order was supposed, these petitioners were
All the persons are there.
It's not not there. Now the thing is that after the dismissal of the Supreme Court SLP petition has been dismissed, now the order needs to be complied with. And whosoever is in charge, these persons are in charge.
No,
Now,
we are abiding with that order, we don't say, we are not
no, you
disputing.
are justifying that.
I am justifying because the construction is required to be completed within 1 year. How within 2 months will a content liabilities comes up against these persons? That is my humble submission. Because if it could have been in March 2020, then the persons who are there occupying that position, that is a different issue. Those persons responsible. But only because in Supreme Court, the SLP.
Long and short of your submission is, since these people have recently joined, this order will not be complied.
No.
Then
we have already,
what are you talking?
plus we have already taken steps to comply. Annexure A1 series
Sir,
understood the spirit of the order, unless we have tried to comply, not that we are sitting silently to us. The last can see Annexure A1 series.
The only issue is in the face of the order of the single judge, how to go ahead with country. That's the only issue.
They have to comply and satisfy the court, because the rest part of the order they have not complied. That I read out the last part of the order.
yes.
They have to relocate that. Unless they relocate, that part of the order is not complied.
The last part of the order also will find. Good.
After summer vacation, in view of this particular order which has been passed, so let them proceed whatever they want to do, otherwise we'll take them.
Let them proceed.
We can proceed with us even now. Because of the order passed by the
If you relocate them,
We are not here to give you advice. You know what to do, what not.
No,
There is a contempt petition.
no,
And we will examine it. You go and tell that single judge. You go and tell the honorable single judge. Get it vacated, whatever it is.
In
That is-
pursuance of the order dated 8/5/2025, Mr. Ashutosh Kulkarni,
Yes, Lord.
Ashutosh Kulkarni, IS Commissioner cum Vice Chairman, Raukela Development Authority. Also, Mr. Lankeshwar Amat,
Secretary.
Secretary, Raukela Development Authority, are present through virtual mode. So, a compliance affidavit has been filed on behalf of the opposite parties, and Sri Lankeshwar Ahmad, opposite party number 2, contemner, on the affidavit, and Mr. Katkia, Land Counsel, appearing for the contemners, place the relevant parts of the affidavit and also the order passed by the Lenin single judge of this court dated 5/5/2025 in WPC number 10570 of 2025. After going through the said order, we put up this, direct this matter to be listed on, fix a date on
That's published,
this show. So
that matter.
date दिया है दो. So let us keep it on first. 6th of May, since
6th of July.
6th of July, since since the date in the swan so is fixed to single bench or WPC, which is fixed to 26/6/2025, put up this matter on 6th of May, July the calendar one. We keep it on 8th of July 2025. It will be taken off at 10:30 and both the contemners shall appear through virtual mode, and the land and counsel for the parties, Mr. Mahantil and senior advocates, also Mr. Katkia, shall apprise this court about the development made in the meantime. Hello? Yes.
Your Lordship can indicate that the pendency of the contempt, they may proceed with the matter.
কেমতি হবে যা
There is no bar.
shall plus
No, no.
We will not say anything.
the direct order shall not be evicted from
You
the
can do
supreme.
an application and before the like single judge.
Wording he shall not.
shall not be evicted from the supremes.
Yes.
সেটা নহলে আমি তাকে ডিসমেন্টল করি করব।
It is done.
We have all regards for this honorable clause. We are ready to comply the order.
8/7/2025. Yes, next.
May I respectfully frame one thing. So for personal appearance of OP number 1 is concerned because he is holding 3 posts, Commission, CMG, and also RDA, VC, so that at least Mr. Secretary, let the Secretary appear virtually, and as and when required, your will direct plus he will appear.
No, let him appear. Yes,
Understood.
next.
Last order, order number 8, where the amount has been lying in deposit were to be dispersed. Clarification was sought for by the collector from the secretary.
Given the
Last order, my lord, order number 8, 23/4/25.
instruction act.
Lying in deposit is 2014, my lord. Photocopy here. They are not giving any copy to me, my lord.
Correct. Please give a handover of copy.
All the time they have been publishing document.
What is your instruction you have received?
So Lordship, that clarification has been already given on 29/4/2025. That's it. Let's go.
Let's go. So in view of the clarification, now there would be no problem.
My lord, these petitioners do not come within that list.
There,
515 that has been turned down. Your Lordship may see
They are coming under that.
in 515, but there was no direction, there was no sanction so far as 515 is
I
concerned.
am coming under 339. I'll show from.
339 is that,
They are
339 is something, 339 is something different, man.
Why?
That was wrong.
within
For
550.
that purpose, we have to clarify everything by filing a proper counter appeal, man. These 515
One
number are totally different.
176 তো করবেন।
দেখুন আমি মোস্ট অফ
I-50 করবেন।
সেইটা নয় স্যার
The election is following with 5.
5, 6,
Is a problem.
Page 42 রে
সেই 42 মেবি ভবিষ্যৎ
no writ petition.
yes, what is there in 42?
Page 42 ରେ list ଟା ଦେଇଛନ୍ତି. As per the direction of the RDC, they have to re-verification.
Is I don't
sorry,
ହଁ ସାର୍
515ଟା ଫ୍ୟାମିଲି ପେଜ 42 ରେ ଦିଆ ହେଇଛି ତା ଦେହରେ 339 ଯୋଉମାନଙ୍କ ଆଡିସନ ହେଲା within 515 ମାନ 515 include 339 176 ଫ୍ୟାମିଲି କି ଦିଆ ହେଇଥିଲା that is there this mention ମାନ number of family covered under 176 family balance displaced family is 339 so list is there these petition are also part of the list ମୁଁ ଯଦି ଦେଖେ ଗୋଟେ ଗୋଟେ your lordship may see writ petition number 1 that is 64 First Bordenwall गाँव में 64 serial
No, we just want to cut short the matter. That is why we asked for the instruction.
Yeah.
Now, since the negative thing is coming, so let them file the counter affidavit so that we will get the opportunity to file the rejoinder and the matter will be hard on merit and it will be adjudicated. In pursuance of the order dated 23/4/2025, Mr. Alok Kumar Paul.
No, Alok Kumar. He has been changed.
What is the name?
আপনার নামটা কোন স্যার?
আপনার নাম কোন? স্যার নমস্কার স্যার I am Narahari Shetty, Joint Secretary Department of Water Resources and Incharge Director.
What is the name, sir?
নরহরি সেট্টি
Narahari Shetty.
ট্রান্সফার তাকে রিটায়ার করে
Mr. Narahari Shetty. What is the designation?
ডাইরেক্টর আর
Director.
ডাইরেক্টর
Sir, Joint Secretary Water Resources
Joint
Department
Secretary,
Incharge
Water
Director RR.
No, additional charge. Here direction was given for director RR. So
You are the additional secretary to government.
Sir, I am the Joint Secretary to Government and at present Incharge Director RR.
अच्छा joint लिखो ना लिख लेना ठीक से हाँ joint secretary to government water resources department in charge director R&R appears through virtual mode and the Learning Council for the state has produced the written instruction dated 29/4/2025 of the Government of Odisha Department of Water Resources, wherein it is mentioned that the amount of the online
Page 39 rows.
4/3/8 has already been sanctioned in favor of
Page 39.
176 so and no approval and sanction has been issued for so enumerated so and the same has been declined by the government. So the written instruction is taken on record. Stop. In view of such state of affair, it is necessary that the stop for them. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. The Learning Council for the state accepts notice on behalf of all the opposite parties. Extra copies of the writ petition be served on the Learning Council for the state. Put up this matter 4 weeks for July master date de counter affidavit if any be filed in the meantime solving copy and the Learning Council for the petitioner who is at liberty to file the rejoinder after going through the affidavit. Yeah. This is taken on record for this. Not a second.
That allowing this petitioner to represent 339 families. Order 1 rule 8 application of the I.
Which is the attempt?
I flag A. IA number is 15383.
It will be decided on that. Yes, next. July.
Item 3.
Complaints to minor order manner and prepared affidavit.
Yes, deposit of.
Manner. Originally here with me.
You have gone through it, so now there
Yes,
will be
ma'am,
no
just
problem,
ma'am.
so take instruction words, now there is no problem. The letter was issued 17/1/2020. That was in the page number 28 of the writ petition, that the application for conversion of the agriculture kism to non-agriculture purpose to be allowed, subject to deposit of the conversion fees. So and so, we wanted the document. That document,
The recruiter I could not having and brought to my knowledge. So this will file the contract. Please take a capital provision, right? Subject one. Can you them to reconsider? You can also consider the same and pass it, take a press this matter.
no, what is your prayer in this writ petition?
Passing of the order, ma'am.
Which order?
Which order?
10-5 Annexer 8 series, ma'am.
Which prayer according to you?
Annexer 8 series.
No, come to your prayer portion, let us see that.
Page 22. ma'am.
Page 22.
Ma'am.
Yes, come to that prayer.
May the order passed by the OP number 3 dated 6/5/24 and 10/5/24 in relocation or so and so. Essentially under Annexer 8 series, pertaining to the petition of land, plot number so and so. Some Gharwari instead of Saradas do are illegal, arbitrary, unknown, non-application line as contrary to provisions of law as provided on section 46/30 of the Act, as such as nullity of law and according to violations. With the further, the Congress will further plead to issue announce a directing appeal part number 2 to reconsider the LA case number one. Keeping view that statutory provision, if you consider it and that can dispose of by it.
117 page
Right.
is the impugn order.
No, the compensation amount has been paid, taking into account that it was
18/4/2014, 24 order.
it was an agricultural land or what?
No, it is a Gharwari Kisam converted.
ଘରବାଡି କିସମ ପରା ହେଇନି
ହେଲା
ଏପର୍ଯ୍ୟନ୍ତ ଆପଣ ଟଙ୍କା ଡିପୋଜିଟ ନ କରିଛନ୍ତି
ନାଇଁ ଟଙ୍କା ଡିପୋଜିଟ୍ କରିକି ପଟା ବି ସେମାନେ ଦେଇଛନ୍ତି ନା ଆଇ ମାନେ ଅରିଜିନାଲ the prior to that for RR the also issued. On 11/3 that has issued.
Yes, referred
11/3
order dated 6/5/2024 and 10/5/2024. But if here the orders are of
Now it has to be recalculated
18/4/2024.
on the basis of Gharwari.
The input orders are not there. It is 18/4/2024, but the order has been reflected in the prayer of 6/5/2024.
ଭୁଲ ହେଇଥିଲା ସେଟା ଆକ୍ଚୁଆଲି ଚେଞ୍ଜ ହେଇଛି ଆପଣ କପି ଦେଇକି ଆପଣ ରିପ୍ଲେସମେଣ୍ଟ ଏଇଠି ଦେଖନ୍ତୁ ଆଉ ଥରେ ମାଇଲା ଯୋଉ ପାସ୍ ନା ଅର୍ଡର ଟୁ ରିଗାର୍ଡିଂ ରିପ୍ଲେସମେଣ୍ଟ ସେଟା ଭୁଲ ହେଇଥିଲା ଏଇଠି ଦେଖନ୍ତୁ
the LA compensation award amount
ଆଜ୍ଞା
according to you,
Minus.
that needs reconsideration.
Minus.
On what basis?
Because the land action officer has not.
Where is that order? First tell us, where is that order? Which is that annexure?
And page 118, madam.
118,
18.
18 and 19.
18 and 19.
118.
The case,
Yes.
the case is taken up today. The notifications under section 4.1 of the RFCTLR Act 2013 of the project extension from Musa River Phase was published by notification dated 21/10/2020 for the following scheduled land. Madam. That is pertaining to petition's land. Notification section 11.
ଶରଦ କିଶମ
ଆଜ୍ଞା
ଶରଦ କିଶମ ନାଁ ଘର ବାଡି ଲେଖା ହେଇଛି ତ
ଆଜ୍ଞା
କିଶମ
Kisam land converted had above mentioned boiler case not so and corrected error issued in favor of the on 11/3/2020. However, the land acquisition notification are issued mentioning Kisam of land as Sarada Dui. The earlier Kisam before conversion. Page 118, last paragraph. OLR 88 case number in 2019. Last paragraph. And the corrected error issued in her favor since 11/3/2020. However, the land acquisition notifications are issued mentioning Kisam of land as Sarada Dui, the earlier Kisam before conversion. For peruse the section 20 of the RFCT Act 2020, it is mentioned here that the government in RM department, a letter dated 17/12/2019, has issued instruction to all the collectors to direct that Tahsildar to remain vigilant while allowing the conversion of land to land just before after issue of CR, Social Impact Assessment Notification. As per the provisions of the and under the section 11 of section 4 of RSP 2013, the Work Department, Government of Orissa, by letter dated letter number 1 dated 31/8/2019 for the approved state project under Avada scheme for the year 2019-20. The said plot was converted from Sarada 2 to Gharabari after Works Department letter dated 31/8/2019. The recorded tenant has converted Kisam of land Sarada 2 Gharabari to enhancement of the land compensation amount. Hence, the prayer to consideration of Gharabari Kisam is not allowed. No other petition filed by anyone relating to scheduled land, hence it is entitled to receive the compensation amount in Sarada 2 Kisam. In the meantime, market value of the Moja Samanga has been determined by LO Puri and approved the
He
collector.
had submitted the rent receipt when it was deposited on attack their courier, but here notification was on 31/8/2019.
But these are the disputed fact. You have to go into, you have to consider.
Regarding project.
Red court can't consider it.
Yes.
Relegating. Let them consider. Verify whether it is.
The rent receipt just now he has submitted.
Conversion fee deposit.
हाँ सर पर conversion जो पैसा टा देइछन्ती केबे देइछन्ती 17/1/2020 रे
17/1/2020
ये here the notification was made on 31/8/2000 thereafter it was converted पूर्वରୁ एटा ये
4/10 ହେଇଛି ନା
31/8/2020 17/10/2020 दी 31/8/19 is the notification.
No, madam. Notification is 21/2/2020. 118. 4/1 notification has been made on 21/10/2020. Compensation has to be determined from 4/1 notification as up to matter 26 to 30 of the RSP 2030. This is a regarding scheme. Avada scheme was framed by the government. That's why they are saying that this is a notification by the government. That is not the government.
To file the counter.
the learning council for the
State as per the order dated 8/5/20, the learning council for the petitioner as per the order dated 8/5/2025 has filed an affidavit annexing the photocopies of the receipt dated 18/1/2020 granted by the office of the Tahsildar regarding deposit of conversion fee. So also the copy of the ROR issued on 11/3/2020. The affidavit is taken on record. issue notice on the question of admission indicating therein that the matter shall be disposed of, and the land council for the state accepts notice on behalf of all the opposite parties. Matter of this one, so you will file the counter affidavit. Same, really under. Yes, next.
Item 4.
Yellow में से क्या टाइप रेफर फेगा करते हैं yellow में ना proceed further ना लोग डालते हैं मैं से other
Yes, item number 4.
After that, sir.
What is your good name?
Naik.
Mr. P.K. Naik, Land Council, 6 for an adjournment after summer vacation. Let this matter. Yes.
Item 5.
My name will be recorded. Opposite part number 1 पे हम appearance को.
Mr. Manoj Kumar Pati, Land Senior Counsel, Government of India is present. That is for opposite party. Yes, item 5.
My lord, I may be permitted to place this matter on behalf of Mr. A.K. Nanda.
Yes.
My lord, the petitioner's grandfather has constructed a house and the petitioner family has been residing there since 1949, for which the petitioner has filed an application for settlement.
Where is that application? Where is the application?
So it is in Annexure 2.
Earlier disposed by this court directing for consideration of representation. The representation was rejected against that order. Yes, before this.
Where is the order? Earlier order?
Earlier order 47, page 47. 47, 48 is the operating part of the order. Thereafter, the representation was rejected. Annexure 5, page 49. On the ground, it is classified as forest land that cannot be.
So what can be done? How you are challenging this order? On what point? What
Well,
ground you are challenging the order dated 15/1/25 under Annexure 5?
My lord, the opposite party number 2 has rejected the petitioner claim only on the basis of that the land is for forest. This is
Yes,
forest land.
that's a valid ground.
But my lord, it can be transferred, means it can be
Yes.
transferred
How a forest land can be settled in your favor?
after approval of central government. My lord.
No.
It is there in that
What
order.
is the flaw in this particular order? This order which you are challenging, the
My lord, it is the duty of the state
The,
to take approval from
Hal
state.
Arwar of the case land is in forest kism.
Yes,
The Sabik Arwar of the case land is not available,
not able.
and the land is being enlisted in district level committee report. So the land cannot be settled. That is all. That's all. Why forest land will be settled in your favor? Which has been recorded as jungle.
My lord, may I have a glance to Annexure 6? Similar land has already been settled in favor of one Hemalata Panga.
No,
That is Khata number 1480.
that's not a valid ground.
Kisam is Garovari there.
Are the land council for the petition and council for this case. The petitioner, Shyam Sagodia, has filed this writ petition challenging the order dated 15/1/2025 passed by the Tahsildar Rayagada under Annexure 5. With a further direction, seeking for a further direction to the opposite party number 2, Tahsildar Rayagada. The opposite party number 2 out the opposite party number 2 to settle an area of acre soon 97 decimal by plot number 963, khata number 1502 in favor of the petition. It appears that earlier the petitioner approached this court in WPC number 21511 of 2024 with similar prayer, and this court finding that a representation at the instance of the petitioner is pending before the opposite party number 2, disposed of the writ petition as per order dated 7/10/2024, directing the opposite party number 2 to consider the representation of the petitioner in accordance with law within specified time. Stop. It appears from the impugned order that the opposite party number 2, after receipt of such order of this court, issued notice, and the petitioner was also heard, and the opposite party number 2 verified the Hal Arwar of the case land, which is Forest Kisam, and it further found that land does not find place in the district level committee report, which formed the basis for the affidavit filed by the state government before the Honorable Supreme Court in T.N. Godavaran, so and so, WPC number so and so. And accordingly, it was held that since the Hal Arwar of the case land is Forest Kisam, and the Sabik Arwar of the case land is not available, and the land is being enlisted in the district level committee report, the case land cannot be settled in favor of the petitioner, and accordingly the prayer of the petitioner for settlement of the land in his favor was rejected. The Land Council for the petitioner has failed to substantiate the clause in the impugned order passed under Annexure 5. We are also of the view that since the land has been recorded as Forest Kisam, the opposite party number 2 is quite justified in refusing the prayer for the for recording such land in favor of petition. Accordingly, we find no merits in the writ petition, same is dismissed. Yes.
Item 6.
May I please, my lords?
Have you filed that copy of the original
Yes, my lord.
application?
I have sought and filed, ma'am.
Yes.
The case of petition before my lord is that being aggrieved the order of dismissal dated 17 March 2025 passed by the learned tribunal rejecting his claim for grant of third financial operation under MSCP scheme is before my lord. May I pray, my lord, 6 is the operating portion of the order. Lord, sir, kindly give glance. I am placing that para. May I pray, my lord, my lord? I am placing last 8 lines, my lord.
Page 25.
Page 75, my lord. Internal page 8 of the terminal of learned tribunal.
Yes.
In the said scheme, fulfill my lord, last 8 line I am placing, which is not part of the proceedings, either myself or department, my lord. So far, my claim is concerned. My claim they have rejected on the ground that I have granted 2 promotions, regular promotions, and 2 final upgradations. As such, I am not entitled for any further upgradation. There is no case that I have not completed 30 years of qualifying service for grant of third final upgradation. But tribunal gave a finding that as I have not completed 30 years of regular service, I am not entitled for third final upgradation. That's why I want to place last 8 lines. In the said scheme, fulfillment of the regular service, that is 10, 20, 30 years without any promotion, is a precondition. It is not in dispute that casual and temporary status period of service rendered by an employee before being regularization cannot be counted for grant of final operation under the SCP or MSC scheme, as the case may be.
Yes.
This finding, my lord, I want to place, no, this finding is not correct, as because by issuing subsequent clarification, the scheme has been modified. Decision taken by the railway board to count 50% of temporary status service so far SCP and MSCP is concerned on the analogy that the same has been computed as a qualifying service for the purpose of pension. I have enclosed, my lord, both circulars, page 35 and 36, my lord, kindly give glance.
Just a minute.
RB number 215, 2009, man. Para number 213.
Three. Para 3.
Mile.
35 para 3.
Mile.
So, you come to that duty upon chadile, our next sentence to put the applicant himself has stated, did you get it, that page number, internal page is 8 and running page is perhaps 75 or 25.
Last 2 lines. The applicant himself has stated that conformant with temporary status with effect of 1181
Yes.
was regularized with effect of 1/4/1990
Yes.
in take 2, and by order of this bench, he was granted first final operation under SCP scheme on completion of 12 years service with effect of 110.
So there is no dispute about that.
No, man.
Okay, then read next sentence.
Thereafter, it is stated by him that he was granted second final operation under MSCP with effect of 19/2008 on completion of 20 years of regular service.
Yes.
According to the respondents, applicant was regularized in the post of Saranga 3 with effect on 1/4/1980 by order dated 7/6/1999. The corollary of facts, stated above, is the irresistible conclusion is that in no circumstance the 30 years regular service of the applicant comes on 31st May 2014 or even before retirement on 31st month 2015. To that, my lord, I want to place my PPO, my lord. My PPO, pension payment order, which shows that after completion of 31 years of qualifying service, I retired from service, my lord.
Where is that?
I am placing page 37, my lord.
37 of your repetition.
My lord. Annex 7, page 37, my lord. So, date of retirement was box to tell it. 31 months 15, net qualifying service 31 years, my lord. So my submission before, my lord, is that I have completed the statutory period of 30 years, my lord, and entitled for third upgradation. My case is rejected by the department on the ground that I have granted 2 promotions, 2 upgradations, my lord. So the promotion which they have stated, that was under challenge. No. My submission was that no, these are not promotions, because the orders which they are saying promotion, it was under judicial scrutiny in a series of original applications. They lost the matter there. A writ petition filed, the issue settled by my lords, and on basis of that,
all these documents were placed before the tribunal.
I have placed the order of my lords. I placed the order, and the order tribunal taken the same into consideration, but rejected that it cannot. It is not similar.
No, this what my brother asked, that this 31 years of qualifying service as per Annex 7.
Your PPO.
PPO was there, my lord. And that is so far my qualifying service concerned, there is no dispute by the
PPO.
present opposite parties, my lord.
Annex A by 4 before tribunal. index.
So far the issue is concerned is no more recent data in view of Miller's order that I have enforced. And that also I have filed before the Law Tribunal along with my reason under Miller. Your Lordship kindly give a glance. Page 59, Miller. The order passed by this honorable court in WPC number.
All right, ठीक है, देखो, the writ petition has been filed by, नहीं, it लिखी जाऊँ तो as per the order dated 8/5/2025, the Land Council for the petitioner has filed the copy of the original application number 260/00343 of 2020, along with the annexures and counter affidavit filed by the opposite party before the Central Administrative Tribunal with a memo. Stop. The petitioner P. Siva Dashan has filed this writ petition. Yes, you have filed the counter affidavit. Yes, that is why we are asking you to file. Where you?
We are not allowing you issuing notice.
We are issuing notice to you, Land and Council.
He thought he was
No. Is a challenge the order dated 17/3/2025, passed by the Land and Central Administrative Tribunal, Cuttack Bench Cuttack in OA number so and so, under annexure 14, and for the direction to the opposite parties to grant third financial upgradation with effect from 31/5/2024, that is after completion of 30 years of service with all financial superannuation benefits. Stop. The Land Council for the petitioner placed the impugned order, particularly paragraph number 5, wherein the Land Tribunal has been pleased to observe that the irresistible conclusion is that in no circumstances the 30 years of regular service of the petitioner comes on 31/5/2014 or even before retirement on 31/5/2015, as the petitioner did not complete 10 years of service from the date of a grant of second MSCP as a precondition as per the MSCP scheme for grant of third financial upgradation. Stop. The Land Council for the petitioner placed the pension payment order, which is under annexure 7, which indicates that the authorities have mentioned that the petitioner has got 31 years of qualifying service. The Land Council submits that in view of annexure 7, the ground on which the original application filed by the petitioner was dismissed by the Land and Central Administrative Tribunal, not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. You are Mr. Patnaik, no? Mr. Darpanaran Patnaik, Land Council, Senior Panel Counsel for Government of India, along with Mr. P.K. Padis, also accepts notice on behalf of all the opposite parties. Extra copies of the writ petition be served on the Land Council for the opposite party. Matter be placed after 4 weeks. Counter affidavit be filed in the meantime. Yes.
Oblige.
Item 7.
It taken up after this.
You are Mr. Das Mahapatra, Mr. Suryakant Das Mahapatra, Land Counsel, appearing for the petitioner, 6 for an adjournment. List this matter after entering summer vacation. Yes.
Item 8.
8 and 11 are same.
8 and 11 are the?
11, 8 and 11.
Yes.
Similar matter.
Similar
matter, your lordship also.
What is the prayer in this?
Prayer, my lord. Put those.
Yeah.
All these persons are land outstay. The land has been acquired by for the purpose of narco. The scheme has been formulated by the government, by the narco authorities under Annexure 2 to rehabilitate the persons those who have been, whose land has been acquired for the purpose of the project. Thereafter, my lord, they have been imparted the training in the different cadres, fitter, electricians, and like this. And they have, but after completions, they have not been engaged in the
Similar matter.
Your lordship has issued notice, batch matter. That is usually one of them. 5 matters has already closed.
Christians should not be appointed as fitter.
Here are electricians.
Electrician.
Change করে দিয়ন্তু আর যাহা চেঞ্জ করে দিয়ন্তু ডেট গুড়াক
এই যে other
Necessary correct.
আদার যাহা চেঞ্জ করে দিই পেন্সিল রে করে দিই
পেন্সিল রে এজ তারপরে ইয়ে যেটা চেঞ্জ হবে তারপর କରିକି দেই যাও সো কিছু নোটিস କରିବେ
দিটা দেবে 7 রে উঠ দেবে 11 রে উঠ দেবে
ସେ ଇଏ ଦିଟା କଣ ଇଲେକ୍ଟ୍ରିସିଆନ ନା ଅନ୍ୟ ଅଛି
ଆରଟା ହେଲା ଫିଟର, ଏଇଟା ହେଲା
ନାଇଁ ଟିକେ ଦେଖିନି କରିଦିଅନ୍ତୁ
ଦେଖି
ହଁ
ଅଲଗା ଅଲଗା କରି
ହଁ ଇସ୍ୟୁ ନୋଟିସ୍ ତାର ଉପରେ ଆଇଟମ ନମ୍ବର ଲେଖିଦେବେ
ଆଜ୍ଞା।
ଆଇଟମ ନମ୍ବର 8 and 11 ହେଲା ଇସ୍ୟୁ ନୋଟିସ୍ ହବ ବଟ୍ ଅର୍ଡର ମିଷ୍ଟର ମିଶ୍ର ଦେବେ କରେକ୍ସନ କରି ସେଇଟା ୟେସ୍ ନେକ୍ସଟ
Item 9.
Award passed by the arbitrator. Is under challenging position of court, but similar matters directed to approach the procedure of section 33.
ଅଛି ଗୋଟେ ଅର୍ଡର ଅଛି ଆଚ୍ଛା the petitioner
Award by collector under NHR.
no he has to challenge it in the appropriate authorities not that ସେ କହୁଛନ୍ତି ଆଗରୁ dispose of ହେଇଛି the writ petition has been filed by the petitioners Durga Charana Besra, Govinda Chandra Besra, and Srinivas Besra, challenging the order dated 31/1/2025 passed by the land arbitrator from Collector Mayurbhanj in arbitration case number 39/2024 arising out of LA case number 68/2014. The Land Counsel for the petitioner submits that since against the impugned order, there are alternative remedy available to challenge the same, and he may be permitted to withdraw this writ petition to approach the appropriate authority. In view of such submission, the writ petition is disposed of or withdrawn. Yes.
The arbitration case is the 18.
Arbitration case 39 ଯାହା ଲେଖିଛନ୍ତି ଆପଣ ପ୍ରେୟାର ପୋର୍ସନ କୁ ଆସନ୍ତୁ 39/2024 that is in your prayer portion.
Durga Charana Besra versus page 20 is the prayer. Arbitration case 18/2024.
prayer portion election 39 prayer केते नंबर annexure 6
That is annexure 6.
Shall we 39?
सेटा 39 लेखन
Page 40. Page 4, running page 40, annexure 6. The arbitration case.
Annexure 6, just see 39 only.
39 job कौन भूल कौन हला अपन भी लिखी जन 39 of 2024 and arising out of LA case number 68 of 2024 हाँ ସେଥିରେ ମଧ୍ୟ ଠିକ ଅଛି ଏଇ ଯୋଉ annexure 6 ରେ ମଧ୍ୟ LA case ଲେଖା ହେଇଛି 68 of 20 ଠିକ ଅଛି yes next
Item 10.
10, the order was there to produce and the entire order sheet as per order dated. Where parts, we missed some time. They are good.
Right, the Land and Council for the state seeks some more time to produce the to produce the order General Administration and Public Grievance Department order number 5512 CA dated 27/4/2006 put up this matter summer vacation for the yes
Item 12.
Similar to 9.
अच्छा ये 9 रो जो अछि
12, 13.
just a minute 12 13 आउटे कोडा
22.
22
1.
22
I'm appearing for 51.
हाँ
13.
13
I'm appearing for 51.
हाँ ती जोटे दौचंदी ता ना गुडा लेखि जान
I'm for the 22.
ଆପଣଙ୍କର ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ ର ଯୋଉ କାଉନସିଲ ସେ ଆଗରୁ ଲିଷ୍ଟ ଦଉଥିଲେ ଏବେ ଦଉନାହାନ୍ତି କି ଆଉ ଦଉଛନ୍ତି ତ ଖାଲି ଆପିରାନ୍ସ
Item lecture to?
तो 12 13 ଆଉ ଗୋଟେ ହଉଛି ଆଇଟମ ନମ୍ବର 22 ହେଲା yes
Item 14.
May I please, Your Lord? Carrying in the order dated 16/1/2025, passed by the Special Land Acquisition Officer, the Pixel project, Balangiri under Annexure C. Only the Special Land Acquisition Officer, the Lakshmi Kansi running page 34, rejected the claim of the petitioner that the claimant reference petition under section 64 of the Act was filed beyond the period of limitation. Your Lordship may kindly see 64 to provide you. The authority has power to condone the delay for a period of 1 year. The claim petition was filed within 1 year.
no please give us the dates
That was given. Your Lordship may kindly see. 33, your Lordship may kindly see. The award was passed on 22/2/2023.
good election हाँ award है
And date of publication of the notification was on 14/2/2023. Running page 34, your Lordship may top.
ठीक है तापर
Date of payment of award is 38/2023.
yes
And the application was filed on 24/8/2023. That is within 1 year of the publication of the award. 22/2/24 6 मास और
22/2/2023
माल
ଆଉ ଏଇଟା ହେଲା 24/8/2023 अच्छा देखिए से ଏଟା ଦେ
64 subclause 2 provide.
just
ଆପଣ ଲିଷ୍ଟ ଅଫ ଡେଟ୍ ରେ ଆଉ କଣ କଣ ଡେଟ୍ ଦେଇଛନ୍ତି
These are the relevant dates, sir.
ହଁ
These are the relevant dates for section 16.
ଦେଖନ୍ତୁ ଆପଣ
And section 64, sir.
କଣ ଦେଇଛନ୍ତି ପ୍ରଥମ ଡେଟ୍
Can be extended in a year.
22/3/2023 ଦେଇଛନ୍ତି ଲିଷ୍ଟ ଅଫ ଡେଟ୍ କାଢନ୍ତୁ ଆପଣ ଲିଷ୍ଟ ଅଫ ଡେଟ୍ ଆଣ୍ଡ ଇଭେଣ୍ଟସ୍ କଣ କଣ ଡେଟ୍ ଲେଖିଛନ୍ତି ସବୁ ଡେଟ୍ ଅଲଗା
ନା ନାଇଁ ଠିକ ଏଇଟା ଗୋଟେ ଭୁଲ
ଭୁଲ ଦେଖନ୍ତୁ ଆପଣ ତାପରେ କଣ
22/2.
when you move the application 64 application
64 application was moved on 5/8/2023.
ଆଉ ଗୋଟେ ଡେଟ୍ ଦଉଛନ୍ତି କଣ ଏଇଠି ତ 5/8 ଲେଖିଛନ୍ତି
ଏଠି କଣ 24 ଲେଖା 24 ଲେଖା ହେଲାଣି
କଣ ଲେଖିଛନ୍ତି ଆପଣ
ପାଞ୍ଚ
ଆଠ ଦେଇଛି ମାଲଟା appendix B ରେ 5-8-23
No, no, are you disputing these dates? Jota order a place kurchundi page 33 and 34. That is in the
No,
order
that
dated.
was not dispute.
Adi how MP date charter empty can dates of
ଏଇଟା
those.
22 ଜାଗାରେ 22-3
ପାଞ୍ଚଟା କେସ୍ ତାଙ୍କର ଅଛି ତାଙ୍କର ଗୋଟାଏ
କାର ଡେଟ୍ କାଉଣ୍ଟ ଭାବିଥିଲେ ବସଉଛୁ
22-2ଟା
No, but let us go through this particular annexure order sheet jota 15/1/25, right? So it is 15/1 or 16/1?
15 ରେ ଅର୍ଡର ପାସ୍ ହେଇଛି 16 ରେ କମ୍ୟୁନିକେସନ ଟୁ
Communicate each other. So that slash daba katha na. Upon prayer portion like those in 16/1/25. But in the top of it is upon prayer portion e kon likhendi. So hole 2025 to when the order was passed. Edi order lekha is 15/1/25.
15-1 ରେ ଦେଇଛନ୍ତି କମ୍ୟୁନିକେଟ
Communicate ହେଇଛି ତା ପରଦିନ ଆଚ୍ଛା. So you come to that 64.
60
Yes,
64
64.
Section.
The reference to the authority. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the authority, as the case may be, whether his objection be to the measurement of the land, amount of the compensation, the person to whom it is payable, the rights of rehabilitation and resettlement under chapter 5 and 6.
Come to subclause 2 to B.
Provided further that the collector may entertain an application after expiry of the said period within a further period of 1 year.
1 year.
If he is satisfied that there was sufficient cause not filing it within the period specified in the first proviso. Your Lordship may kindly see running page 22. Para number 14.
So the first period is 30 days.
Mala.
That is 64 of first proviso.
Mala.
तापर यदि कलेक्टर रेफर न कला ताले अथॉरिटी पाखु जीवो जो अथॉरिटी को प्रेयर करियो गला द एप्लीकेशन स्टोर फ्रंट with application shall be made in the present represented if the person who was present also then provided further that the collector may entertain an application after the expiry of the said period means what?
Said period means
30 days.
30 days.
30 days.
Within a period of 1 year. If he is satisfied that there was sufficient cause for not filing it within. So that means you are to, suppose you file it beyond the period of 30 days, then you are to file an application for condoning in that period so that you will be satisfied.
Where is your application? Where have you mentioned?
Annex 3, your Lordship may kindly see running page 22.
Para 14.
Para 14.
What have you written? Just
My lord, the petitioner made relevant person. Last 3 lines. The petitioner made verbal and written complaint about the valuation of the land and tree, as he is innocent, illiterate, and unknown person about the practice and procedure.
that's the explanation.
Illiterate person, rustic villager.
Question paragraph 9.
illiterate person draft करची की जो इंग्लिश रे लिखी छी ना
In paragraph 9, yes.
There is a single line explaining the delay.
The power is with the collector. There is no problem, but you have to specify some reasons actually that is to be given, and the some way in the prayer portion also it should be mentioned that to condone the delay in that line. How किसी न लिखी नहीं 15-14 So, yes,
23.
Madam, what we propose to do is that you are right that the initial ground has been mentioned. And only that delay to make it prove that we actually file an
Application for delay. That will be
mean that what are the
condition, much over.
we file the phase of the written application.
That will be treated.
Beyond that, 1 year we are.
Absolutely.
That would create further problem because in that way, the collector will have more power.
Power to
Yes, but the power only up to 1 year.
1 year.
So within 1 year, he is already filed.
He has already filed.
He could not explain.
Explain the delay.
He filed a definite.
Okay.
That's not the part. Petitioner, Sahoo Hon'Ble. Challenge. Order dated. The opposite part,
Foreman.
Respondent number 3, guys. Respondent number 3.
Opposite pattern. Special, but within bracket I have mentioned special land acquisition officer.
Special land acquisition officer also opposite party number 4.
Oh,
After the people will be respondent number 3. Party number 4. Special land acquisition official. Where of the irrigation project to Paragi. This one. The determination of the power under section 20 for all the area on the ground that has not applied efficient implemented period of time. Cannot be considered somebody is one. And also the solution is the how to study that. It's really 15 months. But now, forwarded to the petition of 16/1/25, which indicates that the hour was marked from 20 to 22. And the application for reference to allow cities was received on 24/8/20 by the office of the party number of the eviction service. Section 64 bracket 2013 R indicates that if a written application is made, within 30 days on the date of application. For the determination of the authority, then within 30 days, you can make a reference to the appropriate authority. However, the second proviso to section 2 of section 64 indicates that the collector may obtain an application after the expiry of the said period with a further period of 1 year, if he is satisfied that there was sufficient for not filing it within the period specified in the first proviso.
For 30 days, 6 weeks. Yes.
6 weeks.
6 weeks.
That is not relates to that 30 days. 30 days of collector power to make the reference. See again. The appropriate authority. If the collector fails to make the reference once, so immediately you have not filed this application within 30 days. Number 2 subsection the applications are stated the grounds on which the objection to the order is taken. Provided that every such applications have been made, person making it which was present or represented before the collector finally died. He made his award which on the date of collector's order. In other cases, 6 weeks of the receipt of the notice from the collector will be 6 weeks. It occurs within 30 days. But in view of subsection 2, the second provision, the hardened box authority we have this application senior fast for a the extension of the DG 1 year for example.
Proviso 2A states the commencement of the limitation. Yes.
See, section 100
Yes.
Within 30 days.
Within 30 days.
Maybe reference.
Yes, sir.
Just the collector say period different offer.
Then
He has to
approach the authority.
authority means lab.
Lab, yes, sir. Yes.
Directly collector to make.
Make such request.
So
Yes,
that goes so far as 64 months.
yes, sir.
Next comes. A period with the arbitrary
Hey.
aid.
That's good.
Number two, the application shall state the grounds on which the order should be made. Provided that if such applications shall be made, if the person making it was present or represented within the collector at the time when he made the award. Or within our
It is date of award is of
2003.
that award
By the
land acquisition.
land acquisition officer. Special land acquisition officer. awarded.
Section 21 notice is on 14/2/2023.
It's as follows. According to Ejuta, according to section 64, so the petitioner should have filed the application within a period of 6 weeks from the date of so and so, and the date of filing of the petition did not lie within a so and so, took place after this once.
Therefore,
Therefore, the above application cannot be entertained and said as accepted. The learning counsel for the petitioner urged that the second proviso, this should be the second proviso, no? The second proviso to subsection 2 of section 64 empowers the collector to entertain an application after the expiry of the period as mentioned under clause A and B of subsection 2 of section 64 within a further period of 1 year, if he is satisfied that there was sufficient cause for not filing it within the period specified in the first proviso. Stop. The learned counsel for the petitioner referred to the application under section 64 of 2013 Act by Annexure 3, wherein it is indicated in paragraph number 4 that the petitioner, paragraph 14, that the petitioner is an innocent, illiterate, and unknown person about the practice and procedure, and therefore it would have the
In the name of sufficient cause only is it like problem.
In the
Name of sufficient.
in the name of sufficient cause, he has mentioned only this verse.
Para 14.
Para 14 uttar din, purata uttar din. We are of the view that the claim of the petitioner to forward the petition under the law authority should not have been rejected in a casual manner, mechanical manner, particularly when some reason has been assigned in paragraph number 14. However, and therefore, while
opportunity should have been afforded to the petitioner for
the petitioner to explain the delay by filing a further affidavit, which has not been done in this case. Therefore, while setting aside the impugned order dated 15/1/2025, we remit the matter to the opposite party number 4, the Special Land Acquisition Officer, for fresh consideration in accordance with law, providing the opportunity to the petitioner to file an affidavit explaining the sufficient cause for not filing the written application under section 64 of 2013 Act within the period specified in the first proviso. The needless to say that the
not expressing.
stop. We are not expressing any opinion on the merits of the claim of the petitioner. Accordingly, the writ petition is disposed of.
Yeah. On the road. AC and the AC. Same.
15, 17, 18,
19,
19, and 20.
20, 23. 20, 20.
20 and 23.
23. Okay.
Same out.
23.
The
petitioner has not explained.
No, ସେ ଟିକେ just ଗୋଟେ ground ଦେଇଛନ୍ତି ମାନେ
paragraph 14 में जो लिखा है
Annexure 3 ର petition ର paragraph 14 ରେ ସେ ଖାଲି ଏତିକି ଲେଖିଛନ୍ତି ଯେ petitioner is innocent, illiterate and unknown about the practice and procedure. But
सब copy paste same.
ଏଟା copy paste ହେଇକି ଦିଆଯାଇଛି
ସବୁ petition ରେ same. କିଛି लिखना।
Prayer section 8.
ପ୍ରେୟାର କଣ ହେଇଛି?
18 लिखा है 18 जहाँ तक भी कॉपी पेस्ट कर मार
पेस्ट कर देते हैं
18 रेफरेंस
64
रेफरेंस को 18 रेफरेंस
ऊपर लिखने 64
80 भी क्या करते हैं आप 80 भी दुनिया मिस्टेक कर
डेट उड़ा के सब
हाँ सही কথা
The problem is that we cannot allow you to file the fresh petition because that would be again time bar totally. Now ये जो period टा अछि जो 1 year relaxation करियो बोली सेटा भी पड़ेबो तेणु
राइटली एप्लीकेशन लगांतु एप्लीकेशन कर चेंज करांतु जा करी
हां ताकू सेठी गला परे you change the prayer portion that would be all right. Next. Yes, next.
Item 16.
My lord, I have got 2 plots under municipality Jajpur.
No, what is your prayer?
My prayer is my land has been acquired and it has been, a road has been constructed without my knowledge and without my consent. My prayer is to pay compensation. If compensation is not paid within the stipulated periods, which would be decided by your lordship, then recovery of a possession may kindly be on.
No. Which particular land, according to you, has been utilized for the purpose of construction of the road?
Plot number 82, 1
Kodi lekhichendi kodi sir.
there para 1. Page 3. Plot number 82, 1.
Page number?
3.
Page number 3 kahin?
Sir,
There is none.
plot number 8.
Can. Expedition is not scanned.
Red petition kono scanning hi nahi kira kon? 1 to 8 kono 3 page hi jama 1 80 or 7 80.
ଆପଣ ରିଟ୍ ପିଟିସନରେ କ'ଣ ଫାଇଲ୍ କରିଛନ୍ତି ପୁରା?
Sir,
17 page ରିଟ୍ ପିଟିସନ total.
16, 7.
One, see the index, just see the index. Rit petition 1 to 8.
ରିଟ୍ ପିଟିସନ
Annexure.
ନାଇଁ ତାର ଇଏ ନାହିଁ ଖାଲି ସ୍କାନ୍ ଖାଲି ଫ୍ରଣ୍ଟ ଆଉ ଡିକ୍ଲାରେସନ ଏତିକି ଏଗୁଡାକ ନାହିଁ।
Yes, yes.
Scan 9.
Can.
देखा?
एक ପରେ ସିଧା 7 ଆସୁଛି ଆଉ ଭିତରେ କିଛି ନାହିଁ ଟୋଟାଲ। ଏକ ହଉଛି ପ୍ରଥମଟା ହଉଛି ଇଣ୍ଡେକ୍ସ ସରି ଫର୍ଷ୍ଟ ଟାଇଟଲ ପେଜ ନା ଇଣ୍ଡେକ୍ସ ଟା
ଏଠି annexure ବି କରାହେଇନି। ନାଇଁ ନାଇଁ ଅଛି ଆଗକୁ ଅଛି ବୋଧେ ଆଗକୁ ଅଛି ଉପରକୁ ହେଇଯାଇଛି ଉପରେ ହେଇଛି ସ୍କାନ ଉପରକୁ ହେଇଛି ସ୍କାନ କୋଉଠି ଏଠି
ଗ୍ରାଉଣ୍ଡ କାଇଁ
ଗ୍ରାଉଣ୍ଡ ଅଛି ଏଠି
ରିଟ୍ ପିଟିସନ
ଆନେକ୍ସ ଗୁଡାକ ଉପରକୁ ଅଛି
ଏଇଠି ଅଛି ଏଇଠି ଅଛି
ସେଟା କୋଉଠି
ଉପରକୁ ଉପରକୁ
ହଁ ଅଛି ଅଛି
ହ୍ୟାଗିଂ ଭୁଲ ହେଇଛି
ଏଇଟା କଣ
ଆଗକୁ ହେଇଛି ଆଗକୁ
ଏଇ ଅଛି ସ୍କାନ୍ ଅଛି ସ୍କାନିଂ ଅଛି
ସ୍କାନ ଅଛି ଉପରକୁ ହେଇଯାଇଛି ଉପରେ ସ୍କାନ ଆଗ ପଛ ହେଇଯାଇଛି
My lord, plot number 82, 1.4 decimal of land. And another
you have mentioned in paragraph number 1.
Yes.
paragraph 1.
Yes, paragraph 1.
My
According to you, this particular land has been utilized by whom?
by executive officer, municipality Jajpur, for construction of the road without my knowledge and without my consent, without payment of any compensation thereof, for which I have prayed to.
On what basis you say that your land has been utilized?
I am residing far away from my agricultural land, all
We are
the
not on
agricultural land. When
ଆପଣଙ୍କର measurement କରିବା ପାଇଁ କିଛି ଦେଇଥିଲେ application ଯେ ଅମିନକୁ
petitions have been filed before Honorable Collector, Honorable Executive Officer Municipality, and also Tahsildar Jajpur. But all
ଆପଣଙ୍କର କୌଣସି application ଦେଇଥିଲେ ଯେ ଏଇ ଯୋଉ ରୋଡ ଟା ଯାଇଛି କୋଉ କୋଉ ପ୍ଲଟ ଉପରେ ଯାଇଛି ଆଉ ଏଇ ପ୍ଲଟ ଟା ୟୁଟିଲାଇଜ ହେଇଛି କି ନାହିଁ ସେଗୁଡାକ ମାନେ ତାର ଡକୁମେଣ୍ଟ କାହିଁ କରିବି ଖାଲି ଆପଣଙ୍କର ଆଭରମେଣ୍ଟ ଛଡା there is no basis.
document series of representation have
No,
been.
representation will not do. We have to see that this is the particular road which has been constructed by the municipal authority and it has gone over this plot. And one of such plot belongs to you and you are also to show the ROR and then you can say that for this particular land you have not received any compensation. Now there is at least you have just filed an ROR, that's all right. ROR shows that a particular land has been recorded in your name, that's all right. But the question is that the road has been constructed on this land. Where is the documentary proof? Where is the document?
So, page 11.
रिप्रेजेंटेशन फाइल करी रिप्रेजेंटेशन ने लिखिबे जे मो जमीटा ऊपर रोड हो जाइछि सेमती हेले तो हबनी
Yes, sir. Whenever it came to my knowledge, I measured the land and I knew that the road has been constructed over my plot. Then I
आपण
felt
petitioner may dream of something that more road ta bode seti chali gala but that is not a ground to pay you compensation you are to place before this court some material that the road has been constructed on utilizing one of the your land for which you have not received any compensation.
the next to page 30, I have mentioned it before the Honorable Collector in which grievance cell that road has been constructed over my plot and proper demarcation may be made.
Collector kon jibe seri mapiya pe na
Copy to executive officer, I will also
ପଟ୍ଟାରେ ବି
file it.
ଆରଓଆରରେ ଶୋ କରୁଛି ଯୋଉ 82 ନମ୍ବର ପ୍ଲଟଟା ଦାଖଲ ଖାରଜ କେସ୍ ନମ୍ବର ହେଇକି ବି ଯାଇଛି ଦାଖଲ ଖାରଜ କେସ୍ ନମ୍ବର 3541 ପ୍ଲଟ ନମ୍ବର 82 ରୁ 0.25 ଡିସମିଲ ସେ କାହାକୁ ବିକିଥିବେ ଯଦି ତାଙ୍କ ନାଁକୁ ଯଦି ଯାଇଥିବ ଦେ ଆର ଏଣ୍ଟାଇଟଲ୍ଡ
ନା because no transaction has been made.
ଏଠି 82 ନମ୍ବର ପ୍ଲଟ ଦାଖଲ କରି ଦେଖୁ ତ ପଟ୍ଟାରେ
Page
ପେଜ 9 ଦେଖନ୍ତୁ
page 9, ROR, copy of ROR. No, 9.
Look on, the petitioner has filed this writ petition. Petitioner Pramila Naik alias Biswal has filed this writ petition with a prayer for a direction to the opposite party number 3, Executive Officer Municipality Jajpur, to pay the award of compensation of the acquired land within a stipulated period of time, with a further direction to hand over the possession of the land so acquired to the petitioner if the compensation is not paid within the stipulated period. The Land Council for the petitioner to the attention of this court to paragraph number 1 of the writ petition, wherein it is stated that the petitioner is the recorded owner of plot number 82 area Ekorsun Swansea first paragraph which has been utilized by the opposite party number 3. Yes, opposite party number 3 for construction of a concrete road to a colony from Canal Road running from Mansapur to Otharnoda. The copy of the ROR has been filed as Annexure 1. However, there is no documentary proof produced before this court to show that the aforesaid plot has been utilized for the construction of the concrete road. Therefore, we are not inclined to entertain this writ petition to grant the relief as sought for. It is up to the petitioner to seek appropriate remedy in accordance with law. Writ petition is disposed of. Yes, next.
Item 21.
Yes, 21. 21. The opposite part number 4, my lord, the executive engineer
R&B Division Nayagarh Malad is constructing a road mall over these 51 plots of the petitioner malad. And it on to page 3 and para 3 malad, I have given the details malad. It is an annexed, it's an annexed to one.
You have submitted your representation.
Malad. On the day of the demarcation, the petitioner came to know that demarcation is doing malad.
Which representation you have given to the collector?
Collector malad, page
That
13.
is when you have given 15/4/25.
15/4.
I'm writing to bring your attention to the unauthorized construction of the road from Sadar Police Station so and so over my private land also. I'm the recorded tenant of the land mentioned above and also in peaceful possession of the same. Despite this, I was shocked to learn that your good office remarketed to construct a road over my land without acquiring the same and without any notice or permission from me. A representation पर अपन किसी response पाए ना, so let it be disposed of.
This one is Gharwadi malad.
Look, the writ petition has been filed by the petitioner Rajesh Kumar Mahapatra with a prayer for a direction to the opposite party number 4.
2 malad, collector 2.
Collector. There is no such prayer in the opposite party number 4. Opposite party number 4, assistant executive engineer, R&B Division Nayagarh, not to make any construction over plot number so and so at Mauja Nayagarh without acquiring the land or paying compensation to the petitioner. Stop. The London Council for the petitioner referred to Annex 4, which is dated 15/4/2025 and addressed to the Collector Nayagarh, opposite party number 2, wherein it is stated that he is the recorded tenant of the plot numbers 142/5802 and 141/5801 under Khata number 1219/3081 Mauja Nayagarh.
This one Gharwadi.
And for the construction of the road from Sadar Police Station to Hitri Barapur Hondoga is aforesaid 2 plots which are private land have been utilized, have been demarcated for construction of the road without acquiring the same or without any prior notice or permission. The London Council for the petitioner submit that though such a representation was made on 15/5/2025, which was sent by 15/4/2025, which was sent by registered post to the concerned authority, but the petitioner has not received any response from the authority, and therefore the authority may be directed to consider the representation in accordance with law. Land Council for the state has no serious objection to such prayer. Considering the limited nature of grievance of the petitioner, we, while not expressing any opinion on the merits of the representation, we direct the opposite party number 2 to consider the representation dated 15/4/2025 in accordance with law, if possible, if necessary, to give opportunity of hearing to the petitioner, and within a period of 3 months from the date of production of the certified copy of the order, 2 days order of this order, and communicate the result thereof to the petitioner within a period of 2 weeks from taking the decision, है ना? According to the exception is disposed of. ना? Yes, next.
Item 24.
Mr. Panda.
Make legal observations. Because this relates to the land oustage of village Lakshmanpur by the MCL authorities, my lords. These people were ousted from their land way back in 1987. And after that, although some of them have been paid compensation in terms of rehabilitation or employment of one member from each family, my lords, the land acquisition officer has intimated by Annexure 1, that is, page 15, that there are certain persons from the oustees, land oustees of village Lakshmanpur, who are yet to be compensated for having secured the acquired the lands. Lordship may kindly come to page 15, Annexure 1.
No. Who are those persons?
Yes, that list is there. Lordship may kindly come to page 15. The list they have enclosed.
Whether the petitioners have those persons or
yes, yes.
So where is the averment that you have not?
Yes, I'll come to that. I'll just.
And how you explain the inordinate delay in?
I'll explain that.
Yes.
Yes. Lordship may kindly come to page 8.
Page
8 of my date petition, page 8, para 8.
Yes.
The present petition is limited to the said 18 families.
No, what are these 18 families? Means, so what?
They have been ousted from the land way back in 1987 under the Coal Bearing Act by the MCL authorities. Now, my lords, the fact remains is that one of these oustees approached this Honorable Court in a writ application in 2018. This Honorable Court disposed of the said matter, stating that since a commission has been formed by the Honorable Supreme Court, the adequate remedy for the petitioner lies there. Now, that order of this Honorable Court, my lords,
there is a claim commission which is now not functioning.
Like our predicament, my lords.
Yeah.
We filed a petition before the commission at Bhubaneswar, my lords. They refused to register it. After sitting over the matter for a few months, they said that you go to the tribunal formed under the Coal Bearing Act in Talcher. So we moved the learned additional district judge come tribunal. But there what happened, the opposite party number 2 and 4 filed the replies. But the tribunal was of the opinion that this is not the forum to adjudicate this case. And we filed a petition stating that we may be directed to move the appropriate authorities. That was rejected, that is Annexure 5. Now, Millers, as situation stands, we have been left remediless. So far as the delay part is concerned, Millers, recently a judgment of the Honorable Supreme Court has come. That is reported in AR 2022, Supreme Court, page 5783. I'm presenting copies for Lordship's Lords. Lordship may kindly come to the first para itself. The oft-repeated aphorism, justice delayed is justice denied, cannot apply with more force than in these proceedings. The applicant writ petitioners, landowners, displaced persons have waited for roughly half the number of years that this republic has existed. They predominantly belong to tribal communities and the lands were first notified and acquired in 1988 for the purpose of coal mining. Yet, they have not been paid compensation. The tangled and tortuous journey of their tribulations have been elaborately documented in a previous judgment of this Honorable Court. Now, that previous judgment of the Honorable Supreme Court was based on a civil appeal wherein the matter was carried from this Honorable Court, Millers. After the 2005 letter as per Annexure 1, the people of Lakshmanpur lodged an agitation. that these people may be given compensation. Now, your lordship may kindly come to Annexure 2. That is at page.
What has been ultimately held in this decision?
Sorry, my lords?
What has been ultimately held in this decision?
Yes.
This decision which you
Yes,
cited.
oblige, my lords. Your lordship may kindly come to para 42. My lords, the paging is at the right-hand side bottom, my lords. Now, after the Coal Bearing Act, my lords, the RR policy of 2006 has come, which has been subsequently amended in 2013. So, on the basis of that, page 19, my lords, para 42, bottom portion.
Page 19, page 40. Yes.
May I read it, my lords? By the provisions of the second schedule to the RR Act 2013, all displaced families losing a house in a rural area are entitled to a constructed house in terms of Indira Awas Yojana specifications. This benefit can also be enjoyed by those who do not have a house but were residing in the area for 3 years prior to acquisition. In case a family in urban area opts not to take the house offered, it will be entitled to one-time compensation for house construction, which will not be less than 1,50,000. At the same time, if any affected families in rural areas so prefers, the equivalent cost of houses may be offered in lieu of the constructed houses. The second benefit is that if jobs are created through the project which benefits from acquisition, the concerned entity should provide suitable training and skill development in the required field and make provision for employment at a rate not lower than the minimum wages to at least one member of the affected family, or arrange for a job in any other project. In lieu of this benefit, a one-time benefit of 5 lakh per family is to be made, or annuity policies which not be less than 2,000 per month per family for 20 years, with appropriate induction in consumer price index for agricultural laborer has to be made. Furthermore, subsistence allowance for displaced families for a comparative 1 year equivalent to 3,000 rupees per month is to be provided. Additional transportation cost for shifting and one-time settlement allowance of 50,000 is payable. Para 43. The provisions of the RR Act 2013, which replaced the old Land Acquisition Act of 1894, have for the first time cast obligations upon the state to ensure that resettlement and rehabilitation is provided in addition to compensation. These rehabilitation and resettlement provisions relate not only to a right to employment for at least one member of the displaced family, but also other monetary and tangible benefits such as land for construction of houses, cash assistance for construction, transportation cost, provision for temporary displacement, annuity and or cash payment in lieu of employment benefits, etc. Furthermore, by provisions of the third schedule, elaborate provisions for the kind of public amenities which have to be provided, such as public health benefits, schools, community centers, roads and other basic necessities have been obligated. All these are in furtherance of the displaced and the larger social justice obligations cast upon the state. Now, the next para, my lords, is very important, para 44. The RR Act of 2013 by section 108 also clearly envisions that the benefit provided by the new law are not to be applied blindly. Wherever there are existing provisions that are more beneficial or provided other better benefits to displaced persons, such families and individuals have the choice or option to prefer either such policy or local law or the provisions of the RR Act. If one goes by the principles underlying section 108, clearly the benefits spelled out under the RR policy 2006 appear to be better and more elaborate.
So this, if this cause of action arose in 1980, or what do you say?
Miller's cause of action arose when a writ application was disposed of by this Honorable Court in 2021, calling upon the petitioner to move the commission formed by the Honorable Supreme Court.
No. That is disposed of, it's all right. But that is that 8 to 2019 order you are referring to.
Milords,
by this court in WPC number 16574 of 2018.
Milords, this is page 4.
Okay.
Page 4.
No, we are coming to that annexure 5, you say that tribunal's order, there also that order has been quoted.
Yes.
So the order was passed that you are to approach the commission.
Claim commission.
Claim commission. So thereafter, what happened?
Milord, the claim commission, with great respect, refused to register our case. They said this is not the forum. The coal bearing tribunal set up at Talchet is competent to, but they never passed any orders because they never registered our case.
Whatever, but you went to the tribunal and
Yes.
tribunal has now passed an order.
Yes, and the tribunal is saying that it is not
Giving you
within my jurisdiction.
liberty to resort to right remedy.
Sorry?
Giving liberty you to resort to right remedy.
Yes.
The last paragraph itself.
Last paragraph. And
However,
Milord,
in the interest of justice, petitioner is at liberty to withdraw the proceeding in order to approach the appropriate forum, claiming his relief as sought for.
and Milords, in this judgment, Milords,
Therefore, you are saying that this proceeding is the appropriate proceeding for you.
it's a double-edged sword, Milords. Kindly come to the judgment of this on Supreme Court, Milords, para 7. Sorry, page 7, last para. No, sorry. What is the typo? Yes. Page 7, Milords, last para. We are broadly in agreement with the recommendations made by the learned amicus. We, however, leave it open to the appellants or any other affected parties to put forward their objections before the High Court / Commission, since we are inclined to leave such matters to be dealt with by the High Court Commission. Now, my lord, frankly speaking,
Commission is not there.
Sorry, Commission is no more there.
So therefore, High Court.
So who is appearing for the?
Milord, this is relating to that Bharatpur area. Normally, Mr. Satyakananda advocate appears for MCL in the Bharatpur area. So if your lordship so desires, I can serve copies of it.
You will appear for 1 and 5. And for this Mahanadi Coalfield, notice has to go.
Mr. Satyakananda normally appears for the Bharatpur area, which is this.
They may engage somebody else. Why we will ask them? Look on the petitioners have filed this writ petition for a direction to the opposite parties to grant the benefits of the RR scheme of 2006 as amended in 2013. As the land austee of village Lakhanpur. As for the later dated 37/2005 of the opposite party number 4, Special Land Acquisition Officer, Mahanadi Coalfield. In terms of the judgment delivered by the Honorable Supreme Court in case of so and so, AR 20. This is the judgment, na?
Yes. AR 2022 Supreme Court. I've given the paging also.
Acha, which it would like on the 2022 live law bracket SC 916. Hello.
Milord's right hand side, the
5783.
Yes.
5783 na 223.
5783.
But in the prayer portion upon 23 लिखिଛନ୍ତି
prayer portion de 2-3 लिखा है maybe I'll correct it
कोटा ठीक
Milord
5-3 or 2-3
8-3 is correct. I think that's an error on my part.
अच्छा देखिए the learned counsel for the petitioners submitted that earlier the petitioners approached this court in WPC number 16574 of 2018. Have you annexed that order?
Because I have quoted that order.
No. What was the prayer in that?
To be granted, I have stated that our prayer was to be granted rehabilitation benefit.
Where is that? Where have you posted?
Yes, I'll just come.
Acha, let me for a direction to the opposite party number 3. Opposite party number 3 which is rehabilitation officer Mahanadi Coalfield Limited. To make payment of fair compensation amount in respect of the land acquired, and also to provide rehabilitation and resettlement benefits. Stop. The said writ petition was disposed of by order dated 8/2/2019. And liberty was granted to the petitioner to approach the claim commission, which has been constituted by the Honorable Supreme Court to hear the grievances of the land houstee in respect of the land acquired for establishment of Mahanadi Coalfield. The Land Council for the petitioner submits that in terms of such order of this court, though the petitioner approached the Claims Commission and filed a petition, but the case was not registered, and he was informed that a tribunal has been set up under the Coal Bearings Act, and he can approach the appropriate the said authority for appropriate relief. And accordingly, the petitioner approached the what is that PTT mane kon you lekhichen the signature achi PTT bracket re CPA talche. What is the full form of PTT, Mr.? In TC case number 16 of 2022. But it was held that
page 36.
While rejecting the petition, the observation was made that the petitioner is to approach the appropriate forum claiming the relief as sought for. Stop. Land and Council for the petitioner place the order passed by the Honorable Supreme Court in the aforesaid case Mahanadi Coalfields Limited, wherein the Honorable Supreme Court has observed that the appellants or any other affected parties are to put forward their objection before the High Court / Commission, and such matters are to be dealt with by the High Court / Commission. The Land Council submits that the Claim Commission is not now functioning in view of since the extension was not granted, and therefore this court is competent to adjudicate since there is no other alternative remedy for the petitioners than to approach this court. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite party number 1 and 5. Requisites for issuance of notice to opposite parties number 2 to 4 shall be filed by 16th of May 2025. Matter be placed 4 weeks after. Counter affidavit, if any, be filed in the meantime. Yes.
What is the name of the tribunal?
that PTT जो वाटा यूज करना
PPT, we are not even getting it on the website.
no no no
ट्राइब्यूनल रा ना कौन आती
tribunal law
Coal bearing act,
कोल बेरिंग CBA तो कोल बेरिंग
CBA, coal bearing act.
PTT कौन
that is
PTT, I mean, it will be found.
presiding officer some tribunal
One tribunal, T is for tribunal.
P is for presiding officer what is the in between
that
P is for presiding. T,
presiding officer TT in some tribunal what is the in between T
we are not even getting it on the website.
PPT
And Milos, that prayer portion, that 5723 is correct.
रजिस्टर को
Page.
पचा ले पाएगा रजिस्टर को पचा दे तो फुल फॉर्म
PTT कौन
PTT ब्रैकेट रे CBA तो जଣା पड़ुची तार चेयर जो PTT रो फुल फॉर्म टा कोन टा करी लिखि दे
it is coal bearing act
हां
coal bearing
नहीं सेटा
you just see the coal bearing act tribunal is defined there
One T may stand for Talcher, one T may stand for tribunal.
tribunal presiding officer
Then again,
Talcher tribunal
I would तार चेयर वाली यूज all right
So that's pure guesswork.
I will see coal bearing act पे define है जो tribunal part time tribunal correct
mention part time tribunal coal bearing act culture yes no
citation টা টিকে বলে 2-3 হবে
সেটা 2-3 হবে সুপ্রিম কোর্ট অনারেবল সুপ্রিম কোর্ট का जो है prayer portion টা ঠিক আছে
हां यानी এটা जो आपण जो लिखि दी
ମୁଁ ଲେଖିଛି ଭୁଲ ସେଟା ମୋ ଲେଖା ଥା
22 सुप्रीम कोर्ट 5723
23
अच्छा এটা हम काटी दउछु 5723 हेलो अच्छा एक तीन का पैराग्राफ प्लेस कर दो यू आल्सो कोट इट फॉरेन काउंसिल टू द रिपोर्ट करते हैं yes one more item is there
Item 25.
If I may please, that petitioner is the landowner bearing khata number 128, plot number 772 under Moja Bara, district Cuttack. While the petitioner is in possession over the land, he came to know that the opposite party authorities, the state, has planned to plan a construction for the widening of the existing road adjacent to the plot of the present petitioner. Without giving any intimation, without giving any prior notice, they are going to make the construction over my land. My
you have submitted a representation
my lord, I have
on
submitted a
4525
yes, my lord, through email, and the physical copy of the application has also been submitted.
it will be disposed of. This petition has been filed by so and so with the following prayer. So they can learn counsel for the petitioner submit that highlighting the grievances of the petitioner. The representation under Annexure 4 series was submitted on such and such date before the collector from district magistrate Cuttack, but the petitioner has not received any response. From the date of production of the certified copy, 3 months later disposal period, if necessary to give opportunity of hearing, and the order is to be communicated within 2 weeks from the date of taking the disposed of.
My lord, till then, no construction shall be made overnight.
Till then, yes. Yes, next.
Lord, unless there has been a status quo order, they will
Yes,
proceed with
next,
the
next.
construction.
they'll give compensation what's the big deal
Yeah.
I was never
Item 26.
My lord, before acquiring my land,
26 is the, what is that, 26?
The report received from the learning trial course, that is
So he surrendered at right time, and on appearance on the petition was granted interim bail, and after availing the same, he surrendered at right time because how will the certificate as a report as still. He said appellant, like, here is the report of the learning trial court which indicates that after availing the interim bail period, the petitioner has surrendered. Yes.
Item 27.
May I lord with you? Under section 302 and 201 IPC for life, accused in custody 12 years ago. Never.
No, why there are 2 bail application?
No,
one is
one bail application. 1644 by 18 in not press mail.
अच्छा लिखो IA number 1644 of 2018.
Not
This is
bail.
an application for bail. The London Council for the appellant does not want to press this application. Accordingly, it is disposed of as not pressed. है ना? तापरे 1270 of 2025. So how many times your bail application has been rejected earlier?
No result. This is the first time.
First time.
It was rejected on 13/7/2015.
Yes, that is correct. Based on the recovery of the insurance also. So now, how many years you are in custody?
12 years and 4 months.
How can we know?
My lord, it is my lord.
Where is the custody certificate?
Custody certificate,
No, my lord.
not called.
No, not called.
So get the custody certificate. The London Council, देखो IA number so and so. This is an application for bail. The London Council for the appellant submits that the single appellant to
Yes, no, for myself. Single appellant.
ଆପଣ ଏଇ ଯୋଉ appeal ଟା ଜଣେ ଫାଇଲ କରିଛି ତ?
My lord, my lord.
ସେଇଆ ତ କହୁଛୁ that the appellant is in judicial custody for about 12 years.
12 years, 4 more.
अच्छा, for more than 12 years. Let the London Council date produce the custody certificate. Put up this matter after summer vacation. Yes, next.
Item 28.
May I please, Your Lord? Yeah, my lord, the appellant is in custody since 5/1/2020.
कौन है जी?
Because your lordship only kindly see PW9. Your my lord, one
कॉपीटा
co-appellant.
देवे ना
Co-appellant of this release on bail, my lord.
जहाँ भी उसे देखिए ना नहीं. The London
Now,
Council
my
for
lord,
the
it is available in the website of this honorable court, my lord.
the London Council for the just a minute. The London Council for the appellant state submit that he is not having the deposition copies. However, since the trial court record has been the trial court record अगर return कर दीजिए ये trial court record नहीं होगा. Original टा ये कोची तो copy अच्छी तो देखिए.
Is there, sir?
अच्छी अच्छी. Listen, since the digital copy of the trial court record is available, he may be permitted to take the deposition copies of the witnesses examined in the trial court in his pen drive. Permission is allowed. Put up this matter after ensuing summer vacation.
A date में kindly please.
आशी वसी सो संध्या पर देखिएगा.
Item 29.
Yeah, please. Excuse my lord. Custody certificate and regarding the custody certificate. Custody certificate. Present release on entry bail, my lord.
किबे जाइए entry bail.
2/9/24.
2/9/24. कितने मास में?
3 months.
3 months. What is the conduct?
We have no criminal activity during the 3 months in King's.
What is the criminal?
Item 30.
Custody and conduct. Minor. Actual undergo period 5 years, 8 months, 40.
Please fill it 302. Minutes, actual minutes, fine. It is jail criminal appeal mailer. No, let's say 10 years, almost 11 years.
Bonnie.
No, he is in Ralph-Jail jail.
This is from
Bonnie God.
Bonnie. If a Lordship will permit me, I will produce the custody certificate.
From the superintendent special judge,
Bonnie
Bonaigarh
is a sub-jail mailer, it's not it.
It is a special jail, Bonaigarh, which indicates that the petitioner is in judicial custody for 5 years, 8 months, 4 days. However, the learned counsel for the petitioner submits that the custody period after 31/3/2020 has not been taken into account, and therefore he may be permitted to produce the custody certificate from the concerned jail authority. Put up this matter after ensuing summer vacation. तो काली कौन करो तुम फास्ट नहीं आ सकता है ना शॉप नहीं आ सकता तापर जो रीड पिटिशन
गुड़ा पछे कर दो
ताकि ये करके आउ भी जहाँ बेल मैटर थी वो तो टॉप कर दियो है ना मेरा पढ़ू नहीं ना चलो